Shri Radhey, Progressive Shorthand, Legal, Exercise 4, page number 9, Dictation, 80 words a minute, ready. Speaker on the merger of the HJC with the INC dated 9th November 2009, full stop. It also declared the 5 MLAs who have filed separate appeals before this court as being unattached members of the Assembly with the right to attend the sessions only. Full stop. It was directed that they would not be treated either as a part of the INC or the HJC party, with a further direction that they would not hold any office either. Full stop. It is the aforesaid directions and orders which have resulted in the filing of the several special leave petitions before this court by the Speaker and the 5 concerned MLAs. Full stop. As a consequence of the order passed by the division bench of the High Court, the 5 independent appellants before have been prevented from discharging their functions as members of the Haryana Vidhan Sabha even before the disqualification petitions filed against from by Shri Kuldeep Bishnoi could be heard and decided. Full stop. Appearing for the Speaker of the Vidhan Sabha, who is the appellant in the appeal arising out of SLP number 54 of 2011, Mr. F. Nariman, Solicitor General of India, contended that this was not a case where the survival of the government depended upon allegiance of the 5 MLAs under consideration, since the government was formed with the support of 7 independents and 1 MLA from the Bahujan Samaj Party. Full stop. Para. In fact, the 5 MLAs against whom disqualification petitions are pending consideration before the Speaker were not part of the government when it was initially formed. Full stop. Mr. Nariman contended that the learned single judge decided the issue of merger in terms of paragraph 4 of the 10th schedule to the Constitution, while holding that the 2 orders dated 9th and 10th November 2009 were not final or conclusive, and that in any event when the disqualification petitions came to be decided, it would be open for the Speaker to reconsider the issue of merger. Full stop. The learned Solicitor General emphasized the fact that there was neither any appeal nor any cross-page objection in respect of the aforesaid decision of the learned single judge, and even if the same fell within one of the exceptions indicated in Vanarashi versus Ram Banarsi versus Ramphal, the judgment must still be held to have become final between the parties. Full stop. The learned Solicitor General urged that all the decisions which had been earlier to this judgment, full stop.